Okay. Next, page 20. How we doing? I know we're knee-deep in regulation, but these are the facts. If I disagree with the determinations of my child IEP team to change his eligibility status, classification, program placement, and I file a request for mediation and due process, what happens to my child? Here it is. Right? What happens, guys? George? What happens? Stays put. Stay put. If you file your request within 15, withdrawal of the request or issue a final decision. What happens if the school district doesn't comply with the decision of the ALJ? You have the right to either go to court to seek an order. Now we're not talking administrative law court, not Department of Ed court. We're talking about grown-up court, Hackensack court. You know what I'm saying? If they don't comply, you can do that. Likewise, and this is probably your question, answers it, the family's going to be at risk for the same thing. Which is why if I bring your attention, don't go there, just parents' rights in special ed, I'm repeating it, wrong name. I'm going to talk to SPAN, somebody. Don't call it this. Call it rights and responsibilities. They're on the hook just as much as the district is. Okay, expedited due process hearing. You might see this sooner than you'll see the end of the road. An expedited due process hearing from an administrative law judge, disciplinary matters. You got a lot of kids that are classified ED, in your group. Boy, I would love to know the classifications. It's not on Goliath, it's just that they are. Kids acting out, he's dangerous, throwing things, hitting people, can't contain them, expedited. If you disagree with the determination of the IEP team that your child's behavior was not a manifestation of his disability, you may request an expedited hearing to get relief. Anyone know what a manifest determination meeting is? I don't expect you to. You need to though. We dealt with this all the time. If a kid is classified with a specific disability, they cannot be suspended or removed from school for behaviors that are part of that disability. This should be an eye-opener to you, because it always is for us. And there's an except.
So I had a kid, he was at a school, and he was
How we doing back then? Not so much.
So he was aggressive. He was put in restraint.
Suspended.
Well, he was
Suspended.
suspended for spitting. And when we called to ask why he was suspended, they said spitting wasn't in his IEP. I told him that I said, well, normally when they put that a kid is aggressive, physically aggressive, he hit his kids and all that stuff, I said normally that's assumed. I said spitting is the least, of the other two. But he punched,
He didn't get suspended for that.
Suspended for spitting. And they didn't even spit on anybody that missed it, but they suspended.
I don't want to know the school district.
Well, I actually called IAIU on them, so.
Yeah. You can't do that. I don't know if the guys in the bleachers heard this, but the kids in school, the kid's got an IEP, the kid's acting out, he's probably behaving with the same ED, acting out, and there's all this stuff, and he got suspended for spitting. The school knew, the school wanted him out. Why? Because he was a danger, and it's highly disruptive. But he was placed there because of that. It's not easy to deal with. So they needed to get him out, but they couldn't suspend him because his behavior is part of disability. I just read that to you. So they suspended him for spitting at not at anybody. At nobody?
Well, he spit, but it didn't hit anybody.
So it wasn't an assault. with a spit. And they suspended him for this, maybe at first. And they said, well, but it's not in his IEP, so it's not part of his disability, so we suspended him. This is an out-of-district. Sometimes us guys in the out-of-district, I'm just letting you know, and this is my world, we can fall between the cracks way easier than the public school can. But I must tell you this, and this is all of us. If you suspend a child from school, you have to file in the state report who it was, what it was, the date. Trenton's recording this. They want to know who's been suspended and why. So I don't know if they filed it. My guess is they never did. But when you suspend a child, you have to put it in writing. You know this. You got to send it to the school district. You got to send it to the family. You got to call the bus company up and say, Johnny's suspended for the next 3 days. All kinds of paper trail. So this isn't crazy behavior on the part of the school, and you had him removed?
Well, yeah, we had him.
He's not in the school anymore. How's he doing?
He's better.
Good. Manifest determination. So folks, if I suspend a student, not part of their disability, for more than 10 days, you won't read this here. You know that. You won't read that here. God knows why it's not in here. But it's real. If you suspend a kid more than 10 days, I don't mean consecutive, I'm talking 10 days, you have to call a manifest determination meeting. That's what they're referring to here at a higher level. What does that mean? You have to bring the child study team in, the family, and the kid, and you're going to revise that IEP to perhaps change eligibility and classification. Why? You cannot suspend anybody for more than 10 days without taking further action.
That's consecutive.
Not consecutive,
So in total.
school year.
Yeah, but my kid was suspended more than 10 days,
Well,
and they didn't do anything.
that's in the perfect world.
He got suspended for bunny ears.
Wow. But that wasn't anxiety.
George, you just got trumped. And I use that term loosely. Sorry, I apologize for bringing that up. That's another discussion. For bunny
He
ears.
would get up and go on for bunny ears on all the little kids.
Are you
all the-
serious?
Yes, and he got suspended for bunny ears. Literally, I had a meeting, and that's what we talked about.
Can't do that.
They told him to stop 3 times, he didn't listen.
So they threw him out of school.
They sent a letter home through a log, they would write to mom. He did it again, they gave him a warning. 3rd time, they were like, no, you're suspended for bunny ears. Literally, I read on the log, bunny ears.
There is no anti-bunny law. Yeah. Wow. See what I'm talking about, reality show? Here, you think you've heard it. Spitting. Right? Here it is, we lived it. Spitting that didn't hit anybody. And she beat him with bunny ears. I see her spitting and raise you bunny ears. So an expedited, folks, is when it's serious, acting out. We can't keep the kid. We're still in due process, but we got to make change. This helps stay put. Remember? Stay put is everything, but we can't manage them anymore. This is expedited. When you got somebody who's off the hook, and you can't keep them in school, you'll get an expedited. Yeah.
So then that you have 2 years for the.
2 years to file due process, yes.
Now, what are they technically looking for out of that, like a lawsuit, or are they looking for, because it's 2 years later.
It's a good question, George. You know what? I can't give you the answer. Revenge, retribution. Somebody said you can get $1 million. There's 2 years after the fact. What do you want? You want to turn back the clock 2 years and re-educate? No. I want my kid to stay in school till they're 21. Now you know you can go to 21, right? That's federal law. You can go to school till you're 21. You don't see it often, but that's the right of every child and kids with disabilities for sure. In fact, look for a time in the not too distant future where that might change a little bit more up. May. Not tomorrow, but my prediction is it's going to change. Anyway, parent may say, kid's 18, getting ready to graduate, and they want to make a case, the district says he's graduating at 18. They say he's not ready. 2 years later, based on what happened when he was 16. Got me? 2 years.
Now, in some cases.
That's just Jeff. I'm making it up.
Those cases though, have they turned to lawsuits?
Sure. Here's one. He's asking, can it turn into a lawsuit? I had the dubious distinction when I was teaching in New York City a very long time ago. I feel like Star Wars. In January, a long time ago. I was a teacher in Brooklyn, special ed, small class, and I had a young man. I can use his name because he's in the law books. It's public. His name is Riley Reed. And, Riley was a little nuts, but, manageable. I didn't have a particular problem with him. We got to do some behavior management and work with him. And he had disabilities, probably was, 10, 11 at the time? Some years later, when I had nothing to do with this anymore, his family filed a class action suit against the city of New York. That's not administrative law charge. That he didn't get a proper education. Class action. And they won. So if you go to New York law, it's called the Riley Reed decision. He's in his 40s now. He's alive. Yeah. So can it go the full tilt? You can go to the Supreme Court of the United States. Absolutely. Just from no communication. I dropped voluntary mediation. Due process didn't give me what I wanted. And I had the means, the wherewithal, and the will to take this to the full extent. With no guarantee it's going to be in my favor. That takes a lot of will. Or complete insanity. All right. 21. We're almost home. Perfect timing. Anytime you see a page with a lot of bullets on it, it's important. But this is the lightning round. So we're gonna move through this, but read it all. What's emergent relief? It's when somebody goes to the bathroom, I think. It's an immediate interim decision on an issue that is related to a due process hearing. The interim decision is made pending the final decision in the case, and it's subject to emergent relief. It's heard quickly and without opportunity. What's an example of it? This is not crazy unusual. It's a little bit of maybe even your stuff. What issues are considered emergent? 1, issues involving a break in the delivery of service, failure to provide. Wow. This sounds like what I just told you about. Crystal, Fairlawn. They're not providing what the IEP says. It's 2 months already because of the facility, so they're not providing service. I'm not looking to make trouble here, but if you needed an example, this could be one of them. 2, issues involving disciplinary action, including manifest determinations and determinations of interim alternative education settings. There it is. Manifest determination comes right up, but I'm just telling you it's 10 days. That's short. Here's the point, guys. If Jeff Kahn's school keeps suspending the kid for behaviors that he's sent there for, should he be in that school? Should I be raising my hand, and we have throughout our history, say, we need a meeting because we feel we can no longer meet the needs of this child. And if you're going to be true to yourself and the ethics of your school, public or private, you got to step up. You can't warehouse a kid. You can't use suspension as a way of maintaining a kid. My school, we struggled with this for decades because the kids that we had were very acting out, very behavioral, very aggressive. And where's the line? How much are you gonna sustain? Where are you gonna go with it? So you're always dealing with this thing. So emergent relief is one of them. Issues concerning placement pending the outcome of due process, issues involving graduation. How about this one, or participation? Have you had anybody that was a senior in high school and they were gonna graduate and the district said, principal said, over my dead body, they can't go? This is not,
They would threaten with that, but they never actually did it.
okay, why did, they did, they threatened. And what changed their mind?
The law.
We've had lots of kids through my history that the district said, are you kidding? Why? Because, appreciate this, be sensitive to this. I had the kid 2 years now. I got the kid when he's 16, and now the kid's 18, we're gonna graduate. Hasn't been in the school district for 2 years. The principal of that school, whoever's the one who's got the stick, hasn't seen the kid in 2 years or know anything about him. But what did the kid do? The kid went over to the principal, because he's BDED, and got nose to nose with him, and actually spit at him. And hit his, I'm making it up. It's not unusual. And, missed him or didn't, got up front with him. Well, that's assault. Put the kid out, kid gets placed, principal has a long memory, it's graduation time. Kid's doing great. All their credits, highest level of the positive reinforcement system, district's real pleased, principal says, over my dead body. Depends how important it is to the family and the kid. And sometimes the kid doesn't want to go to that graduation anymore because they've been out for 2 years. They're going to graduate at my school. But if they want to graduate, they're going to graduate from that building. That principal will not be able to stop it. And this is what guarantees it. In my school, with our kids, 9 out of 10, at least, did not want to go back to their high school graduation. We did a cap and gown. We don't give a diploma. Out-of-district schools don't give high school diplomas. I don't know of one that doesn't. The school district, Hackensack gives the diploma. Oradell gives it. Lodi gives it. They earn it through the credit they're earning through us. You should be familiar with this. But we do a cap and gown.
So would they go to both, or?
They could.
Okay.
They're never the same day. They could. We encourage it. But most of the time, they don't want to. Because they're out of that system. That's a stigma. We have amazing graduations with cap and gown. And if the district cooperates, and they always do, we ask for their diploma. We give them our certificate, which is not official, but it's a certificate of achievement. And we give them their high school diploma, we take pictures. Everybody cries. And then we have cake and milk. And that's what we do. They love that graduation because at the high school graduation, this was up close and personal, and it meant something to them. But if they want it, as you found out, it's theirs.
So who would you contact if the
Child study team. Case, you're the care manager, you know this, we'll repeat it. Your mirror in the school district, if it's special ed, is the case manager. They use the word case, you use the word care. But you're doing the same thing. You're providing services for the child, and you're keeping track of everything that's taking place. So again, I can't emphasize enough. Make your new best friend that case manager, if the family will allow you. Tell them what you do for a living. Tell them you're here to help. Talk to them about system of care. Talk to them about wraparound. Talk to them about child-family team. But it's got to be an elevator speech. You got 3 minutes. Think of it that way. Else you lose them. Okay? So that's who you talk to. By the way, in this case that I just gave you, that case manager already knows what's coming. You will not be surprising them by saying they want to graduate there because they're in the district and they know what the principal thinks. because they've talked about it already, even before you made the phone call. Emergent Relief. What's going to happen there? Administrative law judge is going to say, principal of the school or district, graduate the kid, unless you can show cause. Okay. How do I request it? Like a due process, put it in writing. Can a parent file for a request of emergent relief through electronic, chorus? No. Never. Never, 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 never. Not when you start on page 14. What happens if I need to request emergent relief after the case has been sent to due process? You're entitled to it. Door's still open. Emergent relief. We want to solve problems. Emergent relief is one of them. Wow. Perfect. Due process hearing rights. Copy this. Get this page out of here and make it right in the folder with your family. The following are the due process rights of both parties. Both parties. Parent has a right to be advised and accompanied a due process hearing. This is you guys. By legal counsel, by individuals with special knowledge or training regarding children with disabilities. Well, I would be allowed in, with all due respect to you, because at this level, they're going to ask me, what credential do I have to be sitting at that table that says I'm a specialist in this? Unless you can demonstrate as a care manager, you have that special. Well, Jeff gave a training. I was at 2 workshops, and he gave me notes. They're going to say, you're excused. You wouldn't be here anyway. Remember why. Bergen's promise not going to allow you to unless judge says subpoena. And I got to be honest with you guys. If I was the ALJ, I'd be subpoenaing your butt like crazy. You know why? Why do you think I'd be doing that?
Did you have a good amount of information?
Yeah. Who knows better? You. And you're almost neutral, but not really. You know what I'm saying? But you have a lot of knowledge of this family and this child. You'd be somebody I'd want to talk to. Nothing to be frightened of, I'm just saying. Just tell the truth. Unless you can't. No. Either party may present, I plead the fifth. This is not that kind of court. Either party may present evidence, require the attendance of witnesses, and cross-examine. Look at the words they're using here, guys. No joke, cross-examine, evidence. They're not putting deposition in there, trust me. Deposition, you know what deposition is, right? Who's been deposed? Really? You have. You live long enough. I'm not saying you're old. I'm not saying you're old. But if, here's what deposition is. Here's what deposition is. Carrie represents the other side, and she's an attorney. And she has the right to depose me, either as the person from the other side or a witness or somebody. And I have my attorney with me, and the mic is on, and she's asking me questions that becomes part of a written deposition that the judge will get. And vice versa. So when you're deposed, you got to appear, or you're in contempt. Either party may get an electronic, finally, written or verbatim recording of the hearing. You have the right to a written electronic word-for-word record of the hearing. The record findings of the fact decision provided to the parent at no cost. So, naturally, you have a right to get the proceedings. You have the right to, parent, ask for and receive a list of free, low-cost legal. See the list of ALJs, you don't care. Have the hearing open to the public. That would be fun. Can you imagine? Have your child present at the hearing if you think it's appropriate. Have an interpreter present. If there's any question remaining from last week, when somebody asked, am I entitled to an interpreter at no cost? Here it is again. You're always entitled to that. Don't interpret. Don't translate. Have the hearing held at a time and place reasonable? Sure. Go to the bottom. Can I appeal decision of the ALJ in his due process hearing if I don't agree with it? Of course you can. But here it is, guys. Look where it can go. And will. The decision of the ALJ in the due process hearing is final and can only be reviewed and changed by the United States District Court or the Superior Court of New Jersey. Wow. Not good. Not good. By the way, when you get to these levels, it is out of your control, parent and district. You no longer own this. You own the case, but it's now in the hands of the court system, of judges, going into chambers, wearing big robes. You don't want to go there. Attorney fees. I'm not going to read it to you, except to tell you this. The family usually shouldn't have to pay for this. But if you lose, parent, the district can come after you for their attorney fees. Judge can decide that. Vice versa. So you're playing a high-stakes game. You got 6 figures running around here. Big time. Who can afford that? Few. The 1% affords that. May the district request attorney fees? Yeah, that's my point. ALJ could say, yeah. Why? You didn't do it the right way. You guys were horrible. You didn't present evidence. You're wrong. This was frivolous. Judge says, pay. Okay, finally. Pretty much. Complaint resolution. Didn't get bad enough. We needed to get worse. A complaint is a concern, allegation, by the way, another legal term, that an education agency has violated federal or state special education law. It's one thing to say, I don't like how you're doing my IEP, which is based on law. It's another thing when you file an allegation complaint against the agency, the district, the state, to say you didn't follow state and federal law. Wow. Remember Riley Reid? That's what that was. They went the whole thing. And they did win. And it changed things. So, I'm not going to get into how a complaint gets resolved. Read it. I don't think your family, one chance in a God knows what, is ever going to go that way. Once again, guys, you are the intersection with this family and the district of getting things cooled off, communicating with them, if they allow you. If they allow you. Crystal's got a family who's looking for services from the CMO that she's not going to get. She feels she's entitled. She got it once. She's not going to get it again. And she won't let Crystal talk to the school district. What can Crystal do? Nothing. She's locked out. She's not going to get permission. So when she approaches her about helping with the school stuff and communicating, you guys, she can't do it. And that's only going to lead to bad stuff. So if you can get that permission, and you can establish the relationship and use the C word, communication, you'll maybe avoid the D word, due process. It's dry what we talk about here, but I cannot overemphasize the importance of this. This is a nightmare if it goes sideways. Bad news for everybody. You will never forget it the rest of your life. Fortunately, you will not be involved in it at that level, but I know you're passionate about your families and want to help them. They're going to go through, win or lose, a nightmare. That's going to cost time and the kid's education. So, hate to end it on a heavy note, but it's heavy. It's serious. So that does conclude this portion of the broadcast.